of Equalization meeting to order. What's first on our agenda?
I'd like to call the roll first. Chairman Runner,
Here.
Vice Chair Ma, Mr. Horton,
Here.
Ms. Hartley,
Here.
Ms. Yee.
Here.
Our first item on this morning's agenda is the Pledge of Allegiance.
And we have Controller E who will lead us.
Yes, thank you. Good morning, everyone. Okay. Please begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
And next, I think we have a photo.
Yes, our next item is the board member annual photograph, so we will
Okay.
recess for 5 minutes.
Recess for 5 minutes. Try to do it faster than 5 because we have a compressed schedule here because
Yes.
the controller
They probably,
has a schedule issue, and then we have an assembly member who needs to, I think, present before they go into session, probably.
Well, we can smile quickly.
Yep.
Yeah.
Okay, we all very situated? Okay, we're gonna deviate a bit from the agenda because we have Assembly Member Todd Gloria, who's with us, who has a presentation for a constitutional amendment, I believe.
Correct.
That that is in the legislature.
True.
Assembly Member.
Thank you, Mr. Chairman. Thank you, Chair Runner and Vice Chair Ma, for your the opportunity to present this item to you today, as well as your indulgence in allowing me to speak so early in your agenda. As the Chair noted, we are going to gavel into session here shortly, and the Speaker expects me to be there. So I bring to you this morning ACA 12 and AB 1596, measures that together would extend a modest but extremely important property tax benefit to homeowners, in this case with disabled children. Specifically, ACA 12 would submit to the voters of California whether to authorize the legislature to extend the ability to utilize a property tax base year transfer to these homeowners with disabled children. AB 1596 would implement these provisions of ACA 12. It would only take effect if ACA 12 is approved. Currently, as you know, most homeowners who are severely disabled are able to take advantage of a once-in-a-lifetime opportunity to transfer the base year value of his or her principal residence to purchase a new dwelling that is better suited to his or her disability. Unfortunately, that law does not apply to homeowners who have severely disabled children to take advantage of this particular provision. This oversight was brought to my attention when a wounded veteran returned home to my home county of San Diego, and his parents attempted to take advantage of this one-time base year transfer. Long story short, the family was forced to endure a lengthy, complicated, and expensive legal process to establish an irrevocable trust for the child and then transfer all or part of that property ownership to the child. I'd like to thank Chair Runner, Vice Chair Ma, and Member Horton for their individual letters of support for these bills. And I'd also like to thank BOE staff for their help in suggesting important amendments to these bills, all of which have been incorporated into the final piece of legislation. I hope that this body will join the California Assessors Association as well as the California Realtors Association in supporting these pieces of legislation.
Okay, thank you. Some discussion by members.
Motion to support.
Second.
Okay, without objection? There you have it.
Easy enough.
Have a good time over there.
Off
Thank
to
you.
do the people's work.
I'll do my best.
Have a good time over there.
Good seeing you.
Okay, what's next on our agenda?
Next on our agenda is the state assessed properties value setting.
Thank you.
Good morning. Chairman Runner, board members, I'm Dick Reisinger, Chief of the State Assessed Properties Division. With me today are SAPD managers Mike Harris and Sam Wong. We are here today to fulfill our constitutional mandate to set the values for the 370 public utility companies in the state of California. Before you is the workbook for the value setting. The workbook is organized by industry groups. Within each industry group, an asterisk appears next to companies proposed as consent items. Companies appear as a consent item when the lead value and staff recommendations are the same. Non-consent items are shaded in gray and represent companies for which staff's value recommendation is different than the lead value. The 2018 lead value is computed using the same value indicator weightings as the final value determined by the board after appeals for 2017. In past years, there have been separate motions to adopt consent and non-consent items for each industry group, or in the alternative, motions to adopt industries in total, and we can proceed however you would like.
Okay, thank you. Some discussion by members? Member Horton, you look like you're ready to ask something.
Yes, thank you, Chair Runner. Just a quick general question regarding the penalties that have been assessed against the various different entities.
Sure.
There's a combination of late penalties, incomplete, failure to file, and willful. How does the staff determine willfulness?
Generally, if a assessee doesn't file for 4 consecutive years, in the 5th year, we consider it to be willful because we've contacted them for 4 years straight and they still don't file.
Are there any circumstances in the assessment of these particular penalties? I'm trying to get to the schedule, but there was a few of them where it appeared to be their first time, but they were late a few days.
in one case 7 days, another up to 30 days. What would be, if in fact they were to appeal that penalty, what would be the basis for relieving the penalty?
And it's been our practice, SAPD's practice, that we generally almost 100% recommend abatement of penalty when it's the first time that they've been late, or in the event it's the first time they've had to file, then we always recommend abatement of the penalty. It's required that they file a written application and they provide, reasonable cause, but if it's a first-time filer, we always recommend abatement of the penalty.
Is there any reason that those penalties can't be abated in advance when we have knowledge that they're the first-time filer?
I don't believe the R&T code section allows that. It requires a written application for abatement of the penalty. So at this point, it hasn't even been adopted yet, and so they couldn't have filed a written application. For these first-time filers and the first time they're late, we do inform them what their rights are, and we encourage them to file the petition because we tell them that historically we grant those
Okay,
petitions.
that was my question.
Yeah.
So we have an inclination or knowledge that this is their first time,
Yes.
that we would, on a norm, abate it if they request. But if they fail to request, it will not be abated. It seems like a condition subsequent. I mean, there's this condition of filing when there's knowledge that the penalty shouldn't apply.
Well, actually, the penalty does apply because they are late, and we don't have any authority to abate the penalty. So we just,
Okay.
by standard practice, we put the penalty on there, and then we let them know that, you have this ability to have the penalty abated if you follow these steps.
Any of the penalties that were assessed, any of them attribute to lack of knowledge or any to our fault that we may have
No,
failed to notify them?
no.
All right.
Member Yee?
Thank you, Mr. Chairman. Going through this value-setting exercise every year, I think one of the things that's impressed me as we move forward is just how much these companies are having to comply with various mandates at the federal and state levels, and certainly regulatory requirements. And I just want to make a suggestion and perhaps a recommendation that leading up to value setting, perhaps this board might want to take some time to delve into what some of those requirements are, so that we can actually put the value setting in a bit of in a broader context. Oftentimes when questions come up as to whether the value is an appropriate value, we're not, I'll just speak for myself, sitting in this position, certainly understand some of the considerations and requirements that companies are under, but when we just see it kind of in its final form after the staff's consideration, which I know the staff diligently works through, I think some broader public transparency around these considerations, I think, would be really appropriate, because these companies are changing. They're having to transform in terms of what's required of them. I know in electric generation, particularly with the environmental mandates, the other regulatory requirements, they have a lot on their plate. And I think with respect to what their production capabilities are going to be going forward, how those considerations might constrain them going forward would be really good topics of conversation outside of the value-setting context, so that we can get that background independently.
Okay. Just to double check, understanding the request then from the controller?
Yeah, my suggestion would be that we kind of started doing that this year in the February and April board meetings, where I tried to give a description of some of the changes. So I think that would probably be the appropriate time. We haven't established the values then.
No,
but we do have a good idea of what the issues are and how
Exactly.
they are impacting values. So
Yeah.
I think that April meeting would be a good time to do
Yeah,
that.
I mean, I know we generally set a couple of times where we talk about the cap rates, and I think a broader, kind of series of considerations might be appropriate, just so there's a broader public understanding about what goes into setting the values.
Right.
So I suppose somebody ought to put that note down, because Controller Yee will probably be the only one here when that is to take place next April. So
We have it written down.
you got that noted, that'd be good. Okay, any other questions?
Not at all.
Okay, in which order, how would you like to take these up, members? I certainly, is there any requirement, or is there any issue for us to take them all up at a single time?
Well,
Or
Industry group.
one do by industry group?
Yeah.
Okay, let's start from the top then with the industry groups and lead off with motions, and we'll just go through them.
Motion to accept staff, state assessed unitary values.
That's for electric generation.
With electric?
electric
Electric
generation?
generation.
Okay, second?
I've got a couple of questions.
Okay.
Mr. Chair.
dear.
And first, let me start out by apologizing. The staff member that normally handles this has gone to Cooper's and Library, I mean, not Cooper's, but Ernest & Young, I believe. And so, to my benefit, I had to review all of this myself. So, and fortunate to have some background and experience to be able to do that. But some questions did come about just for my own edification in some cases, knowing that the questions don't necessarily apply to this year's valuation. Given that there is significant obsolescence and depreciation and as far as electric generation facilities, how is that accounted for?
Well, the obsolescence is, in our cost approach, we measure the obsolescence for electric generation through a couple of different methodologies in our cost approach. We look at underutilization, so if they're generating less electricity than would be expected, there's an underutilization adjustment. If their heat rate, their efficiency rate is below standard, there's also a functional obsolescence adjustment related to the heat rate. And we also have an adjustment that we've just started utilizing in the last couple of years where it's a spark spread adjustment where when they built these facilities, they expected the spark spread, which is the difference between the revenue generated and the cost of the, excuse me, gas. Their expectations were much higher, and the spark spreads were much higher back in 2007, and now those spark spreads have diminished because the natural gas prices are really low and stayed low a long time. Electricity prices have been lower. So we've made that adjustment also. So those are the obsolescence adjustments we make to the cost approach. The income approach, we've started as we've been able to get more reliable, predictable information from the assessees. We've started to weight the income approach to a larger degree. And I think in most cases, we're weighting it 50%, except on the occasion where the facility's only operated for a couple of years. So we've increased the reliance on the income approach. And also, I think you'll notice that in most cases, our value indicators, the values are getting much closer together. In the past, we had a really large difference between income approach and cost approach. And, there's a debate over why that is, but as we've been able to refine the information that we get and improve our obsolescence adjustments and improve the income number projections, those value differences have diminished. So weighting 50-50 seems to be pretty reasonable at this point for a lot of those facilities.
The 2017 federal tax cuts are going to have an effect on all these different industries. How is that taken into consideration, or is it?
Yeah, it is. We definitely took it into consideration. For the rate-regulated utilities, they're really not going to benefit from the reduced tax rates because the regulators are going to force them to reduce their rates, and so the ratepayers are essentially going to benefit from that. So in that case, we've made the adjustment to their revenues to reflect the fact that their revenues are going to be decreased in 2018 compared to 2017 based on the regulators' changes in their rates. So for the larger rate-regulated utilities, there's not much of a change. There's not much impact on value from the tax law. For the unregulated industries, all of them, if there's no expectation that their revenues are going to be diminished by some sort of economic requirement, their values could essentially go up because if your income's the same in 2018 as it was in 2017, but you're paying less income taxes, your bottom line is going to be higher. So our CEA is based on a discounted cash flow analysis. So basically, the CEA values for some industries would actually reflect an increase in value.
And that's always somewhat concerned me because those policies allow the companies to make different tax plans that will ultimately affect their valuation. And so to use that as a general rule is somewhat concerning, but I do understand that that's the way we've done it for years.
It's certainly a complex issue. When you have a tax rate change that's that significant and how it's going to be reflected in, the economics of these industries as they go forward. I mean, it's for most of them, it's going to be a one-year transition because, 2018, by the time you get through 2018 and 2019, all that information is going to be reflected in the marketplace, so we won't have to make adjustments then. It'll just
Just
be.
that initial year.
Yes.
Yeah, in this case, they've got accelerated depreciation.
Yes.
The unitary tax is affected by virtue of the out of the country and so forth. So there are a number of different issues that
Yes.
will have a significant impact this year.
Yeah, it's definitely very nuanced, and when we make our adjustments, we try to do it on a, very high level without getting into all the specific nuances because it would be extremely complicated. In fact, the assessees, these are pretty sophisticated assessees, and they're kind of throwing their hands up saying, well, we know we need to make an adjustment, but we're not sure how to do it either.
Yeah. So, Mr. Chair, if you don't mind, I just got some other questions in the other industries.
Okay, so
I
that
could just-
completes that one?
Yeah.
Okay, so there's a motion, a second on the adoption of the electric generation facilities. Any objection? Okay, so the next item is the energy companies. How about if we get a motion on that, and then we'll have the discussion?
Motion to approve staff.
Motion to approve staff, and a second?
Second.
Okay. Any question, members?
Earlier this month, the California Energy Commission unanimously voted to require solar, which is a good thing, on all new homes. That's going to take a certain amount of power off the grid and so forth, and will ultimately affect the rates to some degree. Was that taken in consideration in the CEA?
Well, for these companies, they're primarily rate-regulated companies, so we follow the rate regulators. So if there's an impact that the rate regulators have reflected, then we would also reflect it just by the nature that we follow their.
Our projections,
Well, actually excuse me, I'm sorry.
Go ahead.
For the major utilities, we don't actually, the projection is really just the prior year's actual historical information.
Yeah.
That's what the rate regulators.
this doesn't go into effect for 2 years, so it's one of those
Right,
questions, yeah.
right.
But you would take
We
it?
would, yes.
Okay, member
All
Yee?
right.
Oh, I'm sorry, are you?
Yeah, I'm finished. Thank you,
Okay.
Mr. Chair.
Thank you, Mr. Chairman. So this is one particular area where, going forward, I'd be curious to see, or just start to have some preliminary consideration about the role and effect of community choice aggregation on these companies.
Yeah, I'm sure it will have an impact. At this point, I'm not sure what that would be.
Yeah,
or
but-
how it's going to be reflected, but it should be, for these utilities, because they're so tightly regulated, all that information is going to be available to us when the CPUC and FERC make decisions, and when they should be taking that into consideration when they set their rates each year. That's going to cause, it definitely could cause I don't know if it's going to be an obsolescence issue or what
Right,
going
right,
forward.
just how we
Yeah.
factor that. Mhm.
Yeah.
Okay.
Member Horton?
Just may follow up. What is the timing impact of this? I mean, the CPUC adjusts the rates. We come in with the estimate of the appraisal within our timelines. And sometimes the CPUC, the adjustment doesn't take place until after we've actually done the valuation. In this particular case, when it does take effect, it'll start at the beginning of the year. We'll do our valuation. The rate adjustment will probably take after our valuation. Tell me how that sort of works itself out.
That's correct. And if you'll notice, for these big utilities, we weight the cost approach, which is HCLD,
Right.
75%, and the income approach, 25%. It's to reflect that it's called regulatory lag, that the additions and the improvements that these utilities put in, they're not in the last rate case, they're in the next rate case. So that's why the CEA is generally lower than the cost approach, just because there's this regulatory lag where the regulators reset the rates and so it takes a while to catch up. So that's why we weight the income approach 25%. That's our attempt to recognize the fact that they're not earning on all of that rate base.
Okay,
Okay?
all right, thank you.
Okay, there's a motion and a second on the energy companies. Any objection? Okay, that passes. Okay, the next one is pipeline companies. Is there a motion?
So moved to accept
Motion and a
staff.
second by Controller Yi. Discussion? Any objection? Okay, that passes. The next one is railroad companies. Is there a motion?
Motion to approve staff
Motion to approve.
recommendation.
Second by the Controller. Any discussion?
Yeah,
Okay.
thank you, Mr.
Member
Chair.
Horton.
Appreciate the opportunity.
He's getting-
There are a few that I have questions with, but I'm going to sort of pose the questions in a general sense, if you don't mind. In the Quincy Railroad and Goose Lake, as you find it, it appears that we use the salvage value as opposed to the historical value and so I'm just curious, are they going concerns? And if we have a going concern that has changed ownership, but there is historical data lead relative to the valuation, but they're a going concern, and we know it's a going concern, and the salvage value, why would we use the salvage value in that case?
Well, for these, I mean, it's historically what the board has used for the short line railroads, which are,
Right.
their income is unpredictable. Sometimes they rely on larger railroads, and so that they're basically, we do an income approach, we look at the income, but we've determined that the minimum value should be salvage value. And for these railroads, the tracks and stuff actually have value. So when we use the salvage value, it would be considered the minimum value. So it would be higher than, say, the historical cost doesn't mean anything for railroads because some of them are so old. The historical cost isn't used and doesn't mean anything.
But in some of the cases, we actually use the 5-year perpetual life
Yes, for the,
on railroads.
Yes,
And
for-
so, go ahead.
I'm sorry.
No, go right ahead.
Yeah, I was going to say, for the larger railroads like UP and BNSF, they are operating railroads that have significant levels of income, and their the income approach value is much higher than the salvage value. So we use the
But it's not based on which one is the highest, even though in this case, the salvage value is $70,000 higher than the 5-year perpetual life value. But is there another basis besides just picking the highest one?
No, I mean, historically, those are the major railroads in California. They have the most car days, they have the most track, and so we have always used an income approach for theirs because the salvage value wouldn't necessarily be useful for that large. I mean, they're not going to go out of business. It's not going to, a salvage value isn't really relevant, I don't think. And so they have an established income stream. They've always been a positive income stream. They have a long-term future, so the income approach is a better value indicator.
So in the case of Quincy Railroad and Goose Lake, the staffs determined that it was not a going concern or that there wasn't enough historical CEA to use the income approach?
I'd have to look at those individuals, but the point would be that even if there was income, it's minimal amounts, and the value, the value of the property is greater in salvage than it is operating. So in that case, salvage value is determined to be the value.
And so from year to year, we would use the salvage value,
We would consider it, yes. We would look at,
even if the CEA contradicts it over a period of time?
well, we'd have to look at it. I mean, if the CEA was greater and increasing and was reliable and predictable, we would consider it.
If I may address the question of the Quincy Railroad,
Just a minute, okay, hang on, so we have a comment from the public. Identify
It is a
yourself,
comment from the
please.
Plymouth County Assessor, whose county the Quincy Railroad lies within.
Okay,
And I'm fairly familiar with the Quincy Railroad. Originally, when it was built, probably back in the 30s or 40s, it had multiple clients. It hauled fuel oil, it hauled freight into town, all of those things. Today, the sole user of the Quincy Railroad and the owner of the Quincy Railroad is Sierra Pacific Industries, which utilizes the railroad to transport finished lumber up to the Union Pacific Railroad for shipment. We used to have 2 railroads of that sort in Plymouth County. The other one was the Collins Pine Railroad up in Chester. A little longer stretch, but
excuse me,
similar
just, can I
situation.
stop you real quick? Can we have somebody decide who's talking
I'm
in back
emailing
of us
right
here?
now.
Go ahead, thank you.
So in the case of the Collins Pine Railroad, eventually Collins Pine made a business decision that it was not economical for them to operate a small railroad strictly for the purpose of their mill. And so they have since taken up all of the track, and now for them to get their lumber to the Burlington Northern line, which is how they ship their lumber out, they actually truck it from the mill up to the line and then put it on the railroads, or on the Burlington Northern, the long-term railroad, or the actual delivery system. So they made a business decision that that small railroad operation was not economically feasible any longer, and I think that when we, at least my perception of perhaps the decision that staff has made is that, again, this is a single client railroad, and it's a short run, and it's expensive to maintain the line, and it's probably shorter for them to ship the lumber by truck as they do in Chester now than it is to use the railroad.
Okay, that's helpful, thank you. San Joaquin Valley Railroad. A similar decision was made where the projected income was $18 million in 2017. For some reason, it dropped to $14.9 million in 2018. The staff used the $17 million salvage value as opposed to the projected 5-year perpetual value. The numbers in and of themselves, you know, with an auditor's background, when you see those differentials, it causes you to pause. What was the reason for doing that?
Well, again, Michael can look at it, but again, it's our position that the salvage value will always be the minimum value because...
Well, this is one of those cases where we actually use the perpetual life value for a period of time. And then all of a sudden, when the projected income dropped significantly, I'm presuming, I can speculate that when you saw the income that dropped significantly, there was an indication that the income approach, because of various different factors, was changing. There were factors that were actually changing and influencing the income. I'm just speculating, but I don't know. I mean,
Well, that's correct. I mean, I still would go to the idea that the lowest possible value for this property is scrap value. So in the instance where the income value...
in this case, it's the highest possible.
Understood.
Yeah.
But it also, the other value, we wouldn't value it less than that because they could stop, it's based on the salvage value, they could stop operating it today, and if they sold everything, all the metal, they could make $17 million. So that's why I'm saying the minimum value we would put on it is salvage value. I mean, they could stop operating and it would be worth $17 million.
That's correct.
Well, I mean, there's a point of diminishing return that's going to exist with all of these entities. And so if that's not the methodology used on all of the entities, you'll find that the salvage value, actually on the larger ones, the salvage value is much higher than the income. Because if they sold off each individual piece, they're going to generate more revenue than they would as a going concern. Typically, the salvage value has a cumulative value, not just an annual value, because now you're selling assets. I mean,
The salvage value
I'm
is...
just from in economics, I'm just going from what I perceive to be the case from an economic perspective. People go in, they buy a company that's not even operating, or they buy a company that is operating, generating significant amount of income. The reason they buy it is because they can sell it off. You know, you can take a car that has a real benefit depending on the type and nature of the car. The parts are worth more than the value of the car. So salvage value, in many industries, including the railroad, typically has a higher value because we're anticipating that the company is no longer a going concern. And then from a valuation perspective, if we change in the middle of the stream, so if we've used the 5-year projection for 5 years, then we go to salvage value, then the income goes up. And theoretically, that is going to affect the previous income valuation
No.
because we use the lower number,
No.
which is now included in the average.
No.
Member
May I
Harkey?
just say something?
Member Harkey, go ahead.
We don't use salvage value unless there's no going concern, and it's going under, correct?
Well, no,
No.
actually, we salvage value for railroads, it's historically, that's been one of the valuation methodologies. Because, and you don't see salvage value in any other industry, but the
Right.
salvage value for railroads is because of the track and all the materials actually have a significant value. And so we get information on what the steel can be sold for.
But
We have-
if you've got a going concern, and then there's more, I mean, you know, salvage value for something like we just heard about, which is really not, has no real functional use, has one customer, might be weighted a whole lot more than the salvage value from a going concern, would it not?
I think that's,
I'm not
if I
sure.
may,
When you're doing your analysis, you don't weight it, you don't take the different factors from a going
Well,
concern?
yeah, I think
You
that-
use salvage value for everything?
we,
I'm trying to
Yeah.
bail you out here from some of this argument,
Well, I
because I
understand
think
that.
you've made proper assessments.
The salvage value is not something we generally weight. We either use it or we don't use it.
Right.
Because it sets a lowest possible value for the property. So in the case where the income approach is really low, it doesn't make sense to value the property at something less than what they could just sell all the steel for.
Right.
So we
Correct.
don't generally use the salvage value is only used in the railroad industry. It's the only one where it's calculated because there's a significant amount of value, and it's not like a going concern value. It's not a business value. It's actually a scrap value.
Yeah,
It's a salvage value.
understood. So if you've got a going concern, though, you know, you've got other factors that you weigh into the evaluation. If you've got something that's going really out of business, I mean, salvage value will be salvage value.
Mm-hmm.
That's just, it's materials,
Right.
it's, you know, it's commodities, for lack of a better term. They're commodities. Okay, I'm just trying to wrap this
Okay.
up, because I
Well-
think their values have been well assessed, and in the cases where we don't have a real going concern, then I think, you know, salvage value is it. But I think the other is, don't they get assessed? I mean, don't you look at salvage value every time you do this?
We determine salvage value for
Right.
all the railroads.
Right.
Okay. Member Horton, you have a
again,
comment?
Mr. Chair, I mean, these are going concerns. And these are going concerns with lead values, with historical values. And therein is my concern that these are going concerns, and that historically, if you use the salvage value, you're generally going to come up with an income that's relatively close, at least the times that I've seen them. In this particular case, your income value in 2017 was 18 million. Salvage value was 17 million. But the salvage value for 2018 dropped for some reason. And so when you use valuations, different valuations, and when you use a salvage value, which is somewhat of a fixed value by virtue that, you know, you've got these assets, it's not the CEA. And so if you use it in subsequent periods, so I would sort of anticipating that the salvage value would not be used if for some reason the income value jumped the following year in 2019. Let's say it jumped back up to 18, but the salvage value remained 17. You would probably use the higher valuation, even though the circumstances are relatively the same. And then if you averaged it out and you included that 17, then it will have an effect on the average value going forward on the projected life. And so that just seems to be somewhat, it doesn't seem to be fair in the valuation to use different methods depending on the outcome when you have a going concern. Because over a period of time, it's all going to adjust itself. It's all going to have the same effect. If the CEA works in 2018, it works in 2019, 2020, unless there's something that changes. And I'm just curious, what was that change? You have a going concern, you have consistent valuation, there's a change. I'm just curious if there's some logic for it. Other than it happened to be the higher than the income.
Well, in this particular case, the operating income did decline significantly, but I think.
But if the property income, using the CEA theory, the basic 5 different types of valuation, if you use one valuation, that theory should apply consistently throughout the life of the operation. Unless there's something that changes. I agree with the member that if they're selling off the operation, then that's a change. The values may drop, they may increase, but at that point, the scrap value has the greatest value.
Okay, Controller Yi has a comment?
Oh, I was just going to say, I think specific to this industry group, I actually like what the staff did because it was quite discerning in terms of the different types of railroads. And so to look at the salvage value as, really the appropriate indicator for short line railroads, I mean, you are going to get your best value with, selling off, obviously, the properties. But that doesn't mean that there's not consideration given to the other railroads that actually do that generate income or that has some predictability with respect to future income, also applying the CEA indicator. So, I mean, I think for me, it's really about applying it consistently year after year. And, I think certainly I understand the logic behind short line railroads and how the salvage value really is where we're going to get the best and highest use.
I mean, we can certainly reevaluate the process that we have used for several years regarding the salvage value and then the fact that the salvage value establishes a minimum value when the property actually has a long-term perspective for operating. We can certainly reevaluate that. That's been the practice we've used for quite a long time, but we can reevaluate that.
And I think that's before us. The issue now is the valuations that are set before us now. And then unless there's a substitute motion here to try to change the valuation process here, or as has been suggested, some kind of valuation or some kind of evaluation as we would move forward. But the motion before us now is on these particular valuations.
I get that, Mr. Chair, and let me be clear. I mean, I believe in consistency. I mean, and the lack of consistency that's causing me to pause. And without any explanation, I mean, if staff was to say, here's the reason, then I could just move on. But the only reason that I seem to have heard is that it was higher than the CEA. And the fact that in the middle of your life cycle, you use a different methodology brings about inconsistency, not only retroactively, but also prospectively, and particularly if that's included in the change in the valuation. If you use a 5-year valuation, perpetual life valuation. So if you revert back to a 5-year perpetual life valuation because that value happens to be higher than the salvage value, it distorts the numbers. That's just math. And that's not fair.
Okay, so the question before us is there's a motion and a second. I don't know if there's a substitute motion.
No, I'm not making a substitute.
I guess
I'm just.
Can I just round out
Listen,
Mr. Horty's
right.
question? So is that what we're doing? Because I didn't think that was,
I don't know. I'm actually asking, the staff hasn't said anything.
I think staff's answered a lot of
Okay.
questions, pardon me, and I think it doesn't seem to matter what they say. The question keeps coming back, and I think.
Well, let's-
answered
Okay,
everything.
let's go back, okay, let's go, again, I think the question's been asked.
Yeah.
Let's have the staff give another answer, give the answer, and then we can move on. And then again, if there's a substitute motion, that's fine. If not, then I think we should proceed, because we certainly have discussed this. And if there's an issue of how to evaluate this in the future, that certainly would be a valid conversation to have, so.
I understand your concern, and we've just followed the practices that we've had in the past well, as long as I've been here, which is 16 years, where it really comes down to just the practice that the salvage value is always going to be the minimum possible value. Regardless of what the other value indicators are, the salvage value is the minimum possible value for the property, because that's, if you just tore the whole thing apart and sold all the parts, you'd get a certain amount of money. So that's going to be, it's our practice to consider that the minimum value. So we're not changing our practices, and we're not changing things in midstream. We're following our practices. It's just that the idea that the salvage value is the minimum value is a driving factor. In this particular case, it's changed from one year to the next.
Okay, Member Yee?
Okay.
just a question. During your 16 years of doing this, has there been a short line railroad that's sold?
I'm sure they've changed hands. They don't really sell.
There has, I mean, in
So they
terms of a
can-
scrap sale?
Yeah, well, I don't,
I know.
we wouldn't get the information on a scrap sale. Once it's gone, it's gone, so.
All right.
But they've changed hands where generally it's acquired by one of the larger railroads, and it's rolled into their system because it provides some function. But nobody buys short line railroad.
Okay, there's a motion to,
San Joaquin is a short line railroad.
Okay.
Yes.
Established.
Yes. Okay, and I just want to ask these questions. And we've used the 5-year perpetual life in the past, and
Yes.
we've changed on this short line railroad,
Yes.
correct? All right,
okay, there's a motion and a second. Is there an objection?
objection.
Okay, please call the roll.
Chairman Runner,
Aye.
Ms. Ma,
Aye.
Mr. Horton,
No.
Ms. Harkey,
Aye.
Ms. Yee,
Aye.
motion carries.
Okay, that carries. And certainly, I guess, at this point through that discussion, there may be some further discussion that needs to take place in regards to the issue, in regards to valuation, scrap values, and how it's applied in the future.
Yeah, I think it's the issue of consistency, so I think to Mr. Horton's line
Right.
of questioning, it's just.
Understood.
Okay? Okay, the next item is the inter-exchange telecommunication companies. Is there a motion?
Move to adopt staff
Is a
recommendation.
motion? And a second? Discussion?
Yeah,
Okay,
Thank you.
Member Horton.
thank you, Mr. Chair, appreciate it. This is one of those questions that doesn't really apply in this particular case, just out of curiosity. There's legislation to address the concerns, including my concerns, about net neutrality. But there's been arguments that the current bill will actually affect the rates. You know what? Now that I reflect back on your previous response to a similar question, I think I've got the answer. Thank you very much.
Okay.
I'm good, thank you, Member.
There's a motion and a second. Any objection? Okay, that passes. The next item is the wireless telephone companies. Is there a motion?
So moved to approve staff recommendation.
Okay, is there a motion? And a second by Controller Yee. Questions? Okay. Without objection? Okay, that passes. The last one is the local exchange telephone companies. Is there a motion?
Move to accept staff recommendation.
Is there a motion? A second by Controller Yee. Discussion with members? Without objection? Okay, that passes. Okay, that takes care of that particular item. Ms. Richmond, what's our next item?
Our next item is item F, other tax program non-appearance matters, F1, property taxes matters. And these items can be adopted in one vote.
Okay. Okay, please.
Morning. Again, I'm Dick Reisinger from the State Assessed Properties Division. Before you, for your consideration, are 2 property tax audit reports,
Anything else you have?
2 land escapes, and 1 roll correction. These routine property tax audits were completed by SAPD staff. The audit reports were sent to the assessees with a 30-day notice to provide staff with any information that might change the audit findings. For these 2 particular audits, no additional information was provided, and the assessees are in agreement with the audit findings. Should you adopt these audit findings, the assessees will be given notice of adoption, and if they do not agree, they have 50 days to file a petition for reassessment. The land escapes reflect escapes related to statement of land changes that were filed late, and then the roll corrections reflect adjustments to unitary and non-unitary land assessments which correct assessee reporting errors.
Okay.
Move adoption of audit report.
Okay, there's a motion.
Second?
And a second by the controller. Without objection? Okay, thank you very much. And the next item? Next item on the agenda?
Next are Chief Counsel matters. Item G, rulemaking. We have a Section 100 change. G1, Property Tax Rule 283, permanent certification.
Okay, we'll hear from the Chief Counsel.
Good morning, Chair Runner, Vice Chair Ma, members of the board. What we have in front of you is an approval to complete the Section 100 process for Rule 283 to make minor conforming changes to this rule regarding permanent certifications. The change is particularly to Rule 283 Subdivision A3, capital B, which refers to a person's experience as a, quote, real estate licensee licensed by the California Bureau of Real Estate engaged in the buying, selling, leasing, or managing of real estate. As you may remember, on July 1st, 2013, the Governor's Reorganization Plan Number 2 replaced the Department of Real Estate with the Bureau of Real Estate and placed it under the Department of Consumer Affairs. On July 1st, 2018, SB 173 changed the name back to the Department of Real Estate and moved it under the Business and Consumer Services and Housing Agency. This change changes the name back to Department of Real Estate and adds a missing comma between selling and leasing. Because this change does not materially affect the rule, we propose to make the change under the California Code of Regulations Title I, Section 100 process without formal notice to the and public hearing process. We don't think it's necessary. This is basically just to make it consistent with the other laws that have changed.
Okay, is there a motion to adopt this controversial?
Move adoption of the
Forth.
Okay, there's a
Rule
motion and
presented
a
by the
second.
staff.
Yes.
But a
You get motion second.
quick question, Mr. Chair.
And a question by Member Horton.
Yeah.
Motion was by Member Horton, the second was by Member Harkey.
Thank you for bringing this forward to us, but it sort of brought my, the certification process. I was going to say, what is the certification process? But the concern is, it's a pretty involved process where the board is required to certify these particular individuals, and so it's a pretty in-depth analysis. Is there any education of the individuals in advance? And if so, what is that process of making sure that the parties who are going for this certification are aware and educated about what it's going to take in order to meet this objective?
Good morning, board members. Dean Kinney.
Good morning, Mr. Kinney.
Yes, board member Horton, there is. We have
Training.
training. We have a course one, which is the basic appraisal one. We provide it in various formats. We provide material to the counties if they want to work with their staff to prep them for the exam. We have one through the American River College where they can sign up and take that one, and it's interactive. And then we have one through SAC State where it's also online and they can do that. So
Okay.
they don't have to take that beforehand, but we encourage it, and we work with the training coordinators in each of the 58 counties.
Excellent. Thank
Okay.
you very much. Appreciate it.
Okay, there's a motion and a second. Any objection? Okay, Ms. Richmond, what's the next item?
Thank you.
Next is the administrative session. Item J is the consent agenda. J1 is approval of board meeting minutes for April 24, 2018. J2, we have report on time extensions for Colusa, Lassen, Mariposa, Sonoma, and Tehama counties to complete and submit fiscal year 2018-19 local assessment role pursuant to Revenue and Taxation Code Section 155. And J3 is adoption of property tax forms, and these items can be adopted in one vote.
Okay. Any question, members, on any of these items on the consent calendar? Oh, no, we'll have a motion. Is there a motion?
So moved.
Motion by Member Harkey, second by Member Stowers. Any discussion on these consent items? Okay. Without objection, these will be adopted. Okay, next item.
Next is item K, other administrative matters. Item K1 is the Executive Director's Report. K11, organizational update.
Good morning, board members.
Good
Dean King,
morning.
the Executive Director. This month's briefing provides updates on the following topics. One, legislative budget hearing for fiscal year 2018-19, budget change proposal, recent appointment, and our goals. Regarding legislative budget hearing for fiscal year 2018-19, the Senate Budget Subcommittee number 4 hearing was held on May 17th, 2018. BOE's board member staffing was one of the vote-only agenda items. The subcommittee adopted the staff recommendation that allows the board members to retain current staffing levels until the end of your current December 2018 term, and as of January 2019 allows board members to retain 2 exempt and 4 civil service positions, and move the 2 positions that are reduced from each board member office to the BOE headquarters. The Assembly Budget Subcommittee number 4 hearing was held on May 21st, 2018. Their agenda also included a vote-only item on board member staffing with the same recommendations to allow board members to retain current staffing levels until the end of 2018, and as of 2019, allow board members to retain 2 exempt and 4 civil service, and move the 2 civil service positions per each board member's office to headquarters. This subcommittee also adopted the staff recommendation, so obviously we'll be monitoring that, and if that's what's passed, interacting to see what the disposition of those 2 positions, how
Yeah,
they're
just
identified.
Just for a quick discussion, the issues that now are not in conference are a bit of a concern. The idea of going from the 6 to 4 civil servants creates a couple of issues to which I don't think they have addressed, and so we've been in conversation to try to get it at least addressed in conference as a not-in-conference item. The 2 items that we think are problematic is basically going, the idea of taking 2 civil servants and assigning them to the headquarters is problematic because some of those folks who they may be assigning may not be in the Sacramento area. Some of those civil servants could be in Orange County, they could be in San Francisco, they could be in LA, and all of a sudden the idea of assigning them to the Sacramento headquarters just does not physically work, and so you end up potentially either, I guess, layoffs or whatever in that process. The other issue that's problematic is going from 6 to 4 without identifying which civil servants you're talking about, what level of service, means who decides that. And again, as you all know, we have a wide range of civil servants that work for us in our offices, anywhere from a receptionist to office personnel to an attorney. And so somewhere along the line, there has to be an identification of which positions we're talking about. And so those are the issues that we've proposed that need to be resolved. Our solution to that is the easiest way to deal with that is just to go with the Finance's original recommendation, which is the 6 civil servants, and then they no longer have to address that issue. So I don't know if there's other discussion, but that's where that discussion is, currently right now. Member Horton.
Thank you, Mr. Chair. I share your concerns in that regard. The positions that have been allotted, and I'm presuming the legislature is going to work all this stuff out, but I guess I shouldn't.
You're optimistic.
But let me back up a minute. Is that we have the members are in somewhat of at least our office in somewhat of a catch-22. In that we're representing ourselves in this process, which seems to be inherently in conflict, to represent us collectively and then represent ourselves. It sort of forces the legislature to look at the opinion of 5 different individuals, when historically in the past, staff has provided the data in order to be able to address some of these concerns. So as it relates to classification, our staff is researching classification, historical classification. All of that data comes from CDTFA in order to be able to justify some historical, which means you've got to do a public records request or some kind of request to get the data. And so I think I'm more concerned about going forward for the stability of the organization. It would seem to me that all of this should be sort of consolidated around the executive director, and to kind of gather the data necessary in order to address the collective concerns of the members. And so I don't know if the existing legislation, and maybe this is a question for Chief Counsel, prohibits that from happening. I know it didn't happen, but was it, the reason it didn't happen is because there's some prohibition?
AB 102 and the subsequent legislation does create a separation between the board member staff and the agency staff, if I can call them that.
I'm actually referring to the executive director.
Right. From the standpoint of the executive director, there are some things that you can direct the executive director to do, and the executive director could try to gather information for him. He's somewhat limited, although it's not entirely clear in the legislation, as to his ability to get that information from, unfortunately, our partner at this time is CDTFA, HR, and we're reliant on a lot of the old staff that used to be previously with the Board of Equalization. There should be a mechanism for Mr. Kinney to be able to get that information from you, but as the board members may know, we've had a challenge in getting timely service from CDTFA, not the least of which because they have a lot of issues themselves that they're trying to work out with their restructuring.
Well, I can tell you, I can tell you, in terms of our conversation that we're having with members, and again, the part of the issue, the challenge is just timing at this point. We've all been in the legislature. We know the issues of where it's going on right now. They're going into conference. They're going to be taking these things up in the next week and a half. I think this item may even come up on Monday. And so the idea of time is figuring out how to expedite the process. I can tell you that in our discussions in regards to, in terms of dealing with the going from the 4 to the 6, the role of the board member and whatnot, we have requested information of the executive director, and the executive director has provided that for us, as we then pass that on then to the legislature and the members. So in that sense, that is happening at that point. I think the problem is I don't think it's the role of the staff at that point to represent then us in that discussion, because I can tell you the legislators aren't looking to them, they're looking to us at that
Correct.
point.
No,
So-
I would agree with Mr. Chair. The question is more of a going forward concern. I understand all the challenges that we're having and the dysfunctionality of this existing system now as we try to work out all of the bugs, but, and I don't think that the staff should be representing the members, but I do believe that to the extent that there is commonality, that it should be accomplished collectively. I, for one, have somewhat deferred to the chair as often as I could in order to have that continuity in communication. And so maybe if we can consider a timing process where there is discussions about the budget, and there are collective requests about data that's necessary in order to be able to deal with some of these issues. And now the issue of classification, personnel workload is somewhat a concern. And I too believe that the State Personnel Board has ruled consistently that having elected officials and appointed officials managing civil service positions is not consistent with the law. And not just this agency, but a number of other agencies where it currently occurs. So the positions that are recommended to be redirected to the agency, any thoughts on how those positions will be used? And are they in addition to the positions you requested, or are they being supplanted somehow?
Well, that would tie into the next point that I can get in on the budget change proposals. But just to address your question, and I believe Mr. Runner did, it's my understanding we did push out to the board members, information on individual staffing. If you believe that wasn't conveyed.
No, you did. No,
Okay. And we
again-
do have a, Ms. Fleming and I have a meeting set up with Cal HR, and, it's one of our top priorities to get some resolution on return rights and so forth. So, and CDTFA has worked with us to get us everything we need, so.
So the specific question I think I heard was, okay, if you get these two
Right.
civil
Regarding
servants from each
that-
offices, have you established the role, positions? How does it work?
Well, I think it gets back to your point. Are we getting vacancies? Are we getting
Right.
individuals with specific skill sets? I would like to, I know Ms. Thompson.
Again, if they assign
I would
for you-
direct some to perhaps the TRA's office.
Yeah.
We have various holes we'll get into here that we feel from
In one
the
sense, you
staffing
may
at
be.
AB 102. So it depends.
Yeah, again, I guess it's a kind of a question that you can't answer until you actually get who they are, because if they say this position moves over here, then you've got to figure out how it fits, if it fits, which is, again, the core of the problem that we're trying to
Correct.
point out to the legislature.
Yeah, but,
Correct.
I mean, I don't necessarily agree that we should wait. I think we should put forth some recommendation as to how you can utilize those positions, and there may be some clarification as to the intent, whether the intent is, whether those two positions are reallocated based on the presumption that the agency needed additional staff to support the board members' offices, and if so, the impediments to that being accomplished, whether those impediments are going to be removed, such that those are civil service positions which can't necessarily work on certain aspects. The majority of what we do, legislation, outreach and education, legal analysis, and so forth, the legislation would be in conflict if that was the intent. And so, and just to go back to the other issue, it wasn't a question of the availability of information to individual members. It was a question of the collective, how do we form a collective thought process and entertain these various different issues? And then, so staff isn't necessarily responding to 5 different members. This particular tour or journey, it appeared that all the members were on the same page. We're asking the same questions, you're given the same material. But there was some instances where there was some difference. So this is just a suggestion that to the extent that Mr. Runner is not successful, what I hope he is, that
Suggested.
we somewhat try to figure out from your perspective, what's the best use of those positions and what's the intent of the legislature in that regard.
Yep. Okay. Other discussion?
Yeah, I just want to say that, I have been advocating for all exempt positions just because this model does not make sense, as we all know.
Right.
So that has been my position, and I've been advocating, behind the scenes, talking to members, talking to leadership. That's all I can say.
I have been likewise advocating for all exempt. These are elected people. When we start mixing all of this around, it gets very confusing. It's a big burden on administration, and we don't have a big administrative staff. And I think all exempt is the way to go. I think that we get a budget, we do all exempt, and then let the members do what they will. I am glad for the return rights for those who wish to return. But I think you're going to get a whole new board next time, and a lot of the people are just not going to be in the right positions for the new board member. And I don't think that should be laid on the doorstep of the new board or the administration or Mr. Kenny to have to deal with all over again. So who from this board is the chair or his representative going to be at the hearings so that he can make public comment?
Well, we have been. We've been at all of them, and comments have been made all the way through the process.
Well,
And unfortunately,
it sounds like
it's in
we're not-
conference right now, so conference, there is no time for
Okay,
public hearing.
Is there any letter or anything that
Yes.
could be sent?
Well, again, here's the issue.
Again?
Here's the issue for us. I think we have tried to make that discussion in regards to the exempt positions. Both budget committees have rejected it. So now the issue is, and again, here's what we got. Remember what happens in the budget committee process. Both committees have adopted the same language. So in essence, that is what they've adopted. They have adopted the issue in regards to the two exempt and four civil servants. That is the language. Now the issue is, how do you get it then as a not in conference item? The only wedge we've been able to find to get it as a not in conference items is the problem they have with the language of going from 6 to 4, and the problems that creates. I think everybody tried their best to try to make the exempt argument. What we heard from members is that was a bridge too far. I disagree. I think they don't understand, but that is where it is. So, again, I would encourage you guys know those members on the conference committee, call them up, and if they want to open it up wider than that, then that's fine, because right now the issue is getting it open. And once it gets open, then if you've got members who are sitting on that conference committee, and you can get them to make the argument for more exempt, that they could take care of that in the conference committee.
Okay, is it possible, since this is being discussed in public, that we get member runner's letter and everything else, and that we're able to sign on and say, me too? For lack of a better.
Yeah, we could do, yeah.
I mean,
Yeah.
I would like that. I don't want to have to recreate the wheel, and I don't want my staff to have to recreate the wheel. But I think it's really important. I do not think, and I've never thought that the legislature really understood what this board does, and they still don't understand the real problems with the board has always been mixing civil servants with exempt,
Right.
with elected members. It's just, it's been shown not to really work well. Our office worked really well, but all of our people were in positions that they really liked. Then you're going to get a new member coming in, and they all chose. I mean, they liked their members. Then you're going to get new members coming in, and it's going to be difficult. And I can just see this going down the road, creating a lot of problems for people and the staff and the legislature, and more smear on the Board of Equalization, which wasn't necessary to begin with. So I think we've just,
Okay.
the lines need to be drawn, and I think this is now the time to do it.
We will pass on to the ED. I think the ED has seen the materials that we've sent, and again, think then at that point, you can forward all of those specific items on to each of the members' offices at that point, and see. But those are the arguments. Those are exact arguments that have been being made, both to individuals and to the groups as a whole. I think the thing that was surprising is, I think for all of us, we thought after testimony at the subcommittees that there was an openness to a number of better directions, and quite frankly, then that came down to the language that was actually voted on was much, much narrower. And so it is a bit of a frustration for us. My opinion is it's a staff-driven issue, and that's why I think it is that you need to, not our staff, but in terms of a legislative staff-driven issue, and I think that is why members need to continue to communicate to the elected out there in conference.
Mr. Chairman,
Yeah.
let me share in that communication. I mean, it seemed to me that, of course, we're all speculating, at least I am, and I've had conversations with the chair of both committees and the staff and so forth, but it seems this is more of a budget decision than it is a legal decision, and I don't know if the law has been entertained as to the legality of what's being proposed. And there may be some concerns relative to the exempt that I think it may be important to express, that exempt positions go through an extensive, for the Board of Equalization, goes through as opposed to the legislature, goes through an extensive vetting process that is not the same as what they may be perceiving. Their vetting process is you.
Do I want you?
Yeah, I want you. That's the vetting process. The vetting process for the members of the Board of Equalization is the exempt is they go through a vetting process with the member's office, then they go through a vetting process with State Personnel Board, and then they actually go through a vetting process with the governor, because these are all appointed positions, which is quite extensive, inconsistent with at least some of the rumors that members can just select as the legislature can. We can't. And so to the extent that can be communicated might be helpful in just the overall education of the members. We've done it to their surprise, but the members we've been talking to are now part of the conference committee. They're not part of that initial process, and they've sort of deferred to those members that were dealing with the initial process, and now that it's...
Yeah, some of them are. Some of them were in those subcommittees. And again, that's exactly what was done. Some of you were there. Some of you had staff at the subcommittee hearings, and those were the exact issues that were brought up at that point. For whatever reason, they seemed to fall on deaf ears. And so I go back to the other issue, and that is right now, it's our best shot is to call up your favorite conference committee member and have your conversation with them. And then we'll move forward. And I think we're all on the same page. We're on the same page. We're all on the same page in regards to 8 staff. That's what we came down to. We're on the same page of more exempt is better than less exempt. So all of that was all part of the conversations that we've consistently had.
Mr. Chairman, just a question to Mr. Nigel. Given that there is a legal issue here, how would we get language to indemnify the members from the exposure of supervising civil service employees? And you can answer that later, somewhere down the road. I just want to make sure that the civil service employees are protected, primarily, and first of all. Then second, the agency is protected. And third, because this is not historical. Historically, this is not what we've done. You know, historically, we have followed the rules to the extent that we could, and the exempt positions were assigned to the agency and not to the members, coding, so forth, and that process, which came into question, I believe, came into question because of the perception as opposed to the reality of what's really happening, or what really happened. And so if we end up going down this road, we certainly need to make sure that there's some clarification that protects all the parties involved.
Okay, will do.
Again, we keep pointing that out, and they don't seem to see the issue. Finance hasn't seen that issue as a problem, and neither has the Ledge Council, which is a problem. So, well, the problem is they have the same issue in other places. They have other elected officials who are basically within their realm, like the lieutenant governor or whoever, who actually have civil servants who work for them too.
They have a whole department.
Well, they got
No, but I'm just saying, if the issue, they have not seemed to identify, which I think is a good discussion, the idea that elected supervising civil servants is a legal problem.
Well, the others actually have a buffer between.
Lieutenant governor, I think, is almost in the same situation we are. So
Yeah.
anyhow, let's,
Okay.
I think we'll continue, we'll communicate. Like I said, I think the urgency of this is your communication right now to those members. Okay.
Okay, members, as I mentioned last month, we submitted a budget change proposal for fiscal year 2018-19, requesting funding and positions to begin addressing the gaps identified following the transition of employees, equipment, property, and funding from BOE to CDTFA. These resources are needed to, 1, carry out the responsibilities that state departments are required to perform, 2, to address the increased workload following the loss of experienced staff transferred to CDTFA, and 3, to augment the BOE legal department's budget to address legal cases and expenses transferred from CDTFA. The gaps in staffing levels impact our ability to execute specific program activities and administrative functions. The most impacted areas include the legal department and the disclosures office. Our previous legal department consisted of over 170 attorneys and staff to perform legal activities for public hearings, tax programs, litigation, settlements, personnel, disclosure, and investigation matters. Following the transition, there were 6 property tax attorneys transferred to BOE, but there were no litigation, board administration, disclosure, or personnel attorneys or staff transferred. Some of the work in these areas is being absorbed by our existing staff, but note, it is not their area of subject matter expertise or duties. A budget augmentation is needed to address the cost and expenses associated with legal cases, disclosure requests, facilities, training, and other general OE&E needs. Our funding and position needs are being considered by the Department of Finance and the legislature, and we will provide updates as more information is known. Recent appointment, I'm pleased to announce that effective May 31st, 2018, tomorrow. Mr. Mark Durham will start his position as the chief over the Legislative Research and Statistics Division. Mr. Durham has served the state of California for 26 years, most recently as the chief of Research and Statistics at CDTFA. We're very pleased to have Mark join our team. Regarding goals, as we approach the one-year milestone of AB 102, the Taxpayer Transparency and Fairness Act of 2017, we have made good, I'm trying not to laugh at the case. We have made good progress reorganizing the BOE, yet there is much more to do. While the staffing level issues impacts our capacity, priorities, and timelines, I'm proud to report that staff continue to accomplish some of our process improvement projects and goals. Redesigning our internet public-facing website to reflect the BOE's current mission and responsibilities and to ensure that our taxpayers and citizens have access to the information they need. Redesigning our intranet, EBO, to provide our employees with full access to their BOE system and to the information relevant to their needs. Updating our BOE policies, separating and transferring our historical records, files, publications, and other documents from CDTFA back to the BOE, updating the board member binder to ensure the new board members have all information they need as they start the new roles. Staff assigned to these projects also have their normal daily assignments, and I'd like to thank the staff and the management for their continued cooperation, support, and their willingness to take on extra roles, responsibilities, and workloads as we work towards standing up the new BOE. Additionally, other goals that I see as critical in order for the BOE to fulfill its constitutional and statutory-related duties includes improving the salary and pay scale for property tax classification and enhancing our recruitment and retention efforts. Efforts to recruit appraisers with property tax experience is progressively more challenging due to the lack of competitive salaries and pay scale compared to the counties and other state agencies. Up until the mid-1990s, we were able to recruit from local county assessors' offices. Now BOE is regularly losing staff to local county assessors. Additionally, within the next year or so, we're anticipating that a significant number of employees with key knowledge and experience will be retiring. This core group is the primary team of trainers used in our succession plan and provide training and written guidance to the county staff as well. Again, I want to publicly thank the CDTFA management and staff who work closely with us on a daily basis. Their support is critical to our daily operations. We truly appreciate their support and assistance. This concludes my report, members.
Okay, Member Ma.
Thank you. Mr. Kinney, we talked way back, this doesn't have to do necessarily with, your budget request, but there was only like 2 people that was able to do some sort of manual process having to do with recording property valuations, and I'm not sure what that was.
I'm not either. Sorry.
This probably came up 2 years ago, and we did talk about it, and you said, yes, that is true. There's only like 2 people, but we're trying to update the system.
I don't know. I'll have to go rack my memory and see if I can.
Okay, I'll have to go back into my notes
Okay.
as well. But there is some process to I don't know, it had to do with the local level, updating, upload, okay.
Okay.
I'll go back to my office and.
Hopefully, we still have both those people. One of them hasn't retired.
Well, I know, well, and that's the problem. It's a very manual process, and I thought you were going to try to.
Oh, I think maybe we're
Figure it out
talking,
or
maybe we're talking,
automate
we might be talking about the state assessment rule, I'm thinking.
Yes,
That is outdated, and it
Yes.
is, have a modernization plan that we're working on, but yes,
Yes.
it is held together with duct tape and Band-Aids.
Exactly.
So, and there are, but Mr. Reisinger does have a succession plan. He's making sure new people are learning it and working on it, so we do have 2 people on that. I'm guessing that might be what it is.
yes.
So we do have quite a few systems that need modernization, and we're working on it. We're working right now on the legal entity ownership program one, and then
Okay.
we'll move on to the.
But is that part of your budget request to modernize this?
I think that will be
Antiquated
in, as we work towards a budget change proposal this fall. So if we don't identify adequate resources, we're transferred over to deal with that. So,
Okay.
yes.
Okay, any other questions on it? Member Horton.
On the parity issue, I thought we had, prior to all of this happening, I thought we had worked something out with, as far as the appraisers having parity, that there was some approval or something that occurred Can you refresh my memory as to?
No,
what's
I
the
think we
status?
started on an effort to do it and kind of align it with the rest of the former
Right.
BOE, the sales tax and use tax areas, and we worked on the managers and supervisors. The goal that was going to go back to the next level of specialist series and put them on, and that stalled out outside of our control with, I think, Cal HR. So we're going to, Ms. Fleming and I, we're going to revisit that. We're meeting with Cal HR. Might be this week or next week, and we'll bring that up, so. But we did make a run at it, and it stalled out, outside our control.
Now, the governor in the legislature, they have a, what is it? Not a concession, but a plan, recession, what's the term? They have a plan where the state anticipates that a number of their employees will retire over a period of years, succession plan.
Workforce succession planning.
Yeah, reverse succession plan. And so part of that consideration is salary parity, in particularly with revenue-generating agencies such as the Board of Equalization, Franchise Tax Board, and so forth. The gap between the salaries for our employees and those in other government agency is getting wider. And in some cases, in the federal government, they actually can take into consideration the cost of living in a particular area and will give you a cost of living adjustment. And so in some areas, our employees are at even a greater disadvantage, which ultimately, when they retire, they end up leaving the state and taking with them their pension and so forth, but leaving the expense with the state. Is that part of the discussions? Are we kind of accumulating data to be able to support?
We have been collecting that. I mean, we worked with the prior board. There was on a workforce succession planning, so we have that data, and we've collected data. We have how many we've lost, how many we've lost to other. We'd worked with our HR in BOE before the split, and we still work with them on the data we would need to gather to
I'd very
support our
much
case.
like to see that data, if you could make it available to our office. The last board hearing, at least the one that I attended, a member expressed, the board discussed, I guess, outreach and education. Any efforts to enhance that division, or any thought of a need to enhance the division? I think one of the testimonies.
In my opinion, yes. If we do get positions, the two from the board member, we would probably redirect some there. I know Ms. Thompson, who's in the audience, did meet up in April with the assessors about outreach and that, per statute, that the TRA, at the request of the assessors, can work with them to provide taxpayer education. They discussed some areas. They identified some areas where they would like us to work on it. So I know Ms. Thompson has a plan on that. So, in my opinion, I think the TRA could use at least one more position right now as we work towards that to develop publications and stuff for the taxpayers, so they aren't trying to understand our little more technical manuals that are written towards the county assessors. So the TRA has a plan for that, yes.
Okay.
Okay, I'm gonna skip ahead on the agenda, and maybe the executive director come back and finish the report. There's a request from a member that move on something else that's further in
End
the
of that.
agenda because of a flight that has to be caught. So I'm going to move ahead to item K32, which is the airline representative period.
Okay.
Okay, please.
Yes. Good morning, Chairman Runner. My name is, and members of the board. My name is David Young. I'm the chief of the County Assessed Property Tax Division, and with me here is Mr. John Loudon. He is the senior specialist, the subject matter expert on this issue. In December of last year, the board directed staff to take a look at the possibility of a 365 representative period as it relates to certificated aircrafts. The board made asked staff to do two things. One, take a look at the feasibility of that, and two, to start an RFI process to see if there are actually vendors that can provide such information. To that end, the staff has conducted 3 interested parties meetings in order to vet the issue. The first one was held in February. In that meeting, assessors represented by CEA and their aircraft subcommittee, airlines, and vendors of this type of information was in attendance. At that meeting, there was a data set that was provided by one of the vendors. The subcommittee and the aircraft subcommittee did analysis and showed that they could actually work with the data provided and to make an allocation with the 365. The second meeting was held in April. In April, we had another data set provided to the board from another vendor of the information. Once again, LA County, who is the lead county for the aircraft subcommittee, was able to make a presentation and use that data in order to do the calculations. So we have performed an analysis, and board staff actually did an analysis and looked at the reliability of that data that was provided. We looked at it and we deemed that it was fairly good. The third meeting we had was just 1 week ago, was in May 23rd. At the second meeting, airline industry asked for a little bit more time to take a look at the data and to do their own analysis. They were provided that time and they were given an opportunity to relook at it. In that meeting also, we asked both the assessors and industry to come to give us their analysis of what it would take to administer such a representative period. The consensus on both sides was that it would be a substantial administrative burden in order to look at 365 days worth of data in order to make that allocation. Since then, airline industry represented by A4A and the assessors have actually started to meet in a smaller working group in order to vet some of the issues. They expressed that the interested parties process, the open interested process, was a little bit difficult to maneuver in. It involved a whole lot of folks, and they asked that they have already started to look at it separate and aside from this process. I believe their first meeting is scheduled for later on this month. They've had an initial meeting, and they're having a working meeting later on this month. The board's directive to us in December was to complete the process, write a report, and bring it back to the board in July. Both assessors and industry asked that they have an opportunity to see if they can come up with other recommendation, and given a little bit of time before we bring it back to the board, they're asked that perhaps they can bring it back in September. The second part of the action that you directed the board staff to do was to start the RFI process. Board staff has actually started that and completed it. With the help of CDTFA, we actually put out a request for information out there, and we got 2 responses from vendors with the information that we were seeking.
Okay. Let me just see if I think where we are then, as you described there, is that we had asked for specific evaluation of a 365 plan that was a specific 365 plan that was, I think, led by the LA County assessor.
Yes, sir.
So that's the 365 plan that you're dealing with was that specific 365 plan. And as a result of the discussions that have gone on, both the assessors and the industry have determined that that is a workload burden.
Yes, sir.
And therefore not one that they would choose to go down. Then on top of that, this discussion has opened up new discussions between the assessors and the industry, to which they are, my understanding is, having positive discussions in regards to a potential solutions. They would like to be, at least my conversations is, they feel like they can come to conclusion by September 1st, which would then allow us to be able, and staff, to be able to address this then in a September meeting.
Correct.
At that point. So if we go forward under that scenario, then obviously the staff shouldn't continue to work on a plan that's going to be presented in July.
Yes,
That doesn't seem to be acceptable to anybody.
correct, sir.
Okay. With that discussion, is there some, Member Stowers, did you have a comment?
When you, am I on? Industry and assessors are going to have these separate meetings to just talk about what? Not the 365, but to talk about, what's the purpose of the meeting?
The purpose of the meeting is to talk about, one, a representative period, which one is truly representative of the certificated aircraft's presence in California, and two, the assessment of aircrafts in general, to see whether there is another assessment scheme methodology that may work a little bit more efficiently, a little bit more easier in the administrative burden for both assessors and airlines.
And will all the airlines be at this table at this meeting?
So far, the setup that I know of is with A4A. They are Aircrafts for America, and the LA County staff and San Mateo County staff.
Okay,
They-
but not all airlines are part of A4A.
Not all airlines are part for A4A. This is something set up between those two counties and A4A. The counties are free to meet with any other airlines they so choose.
Okay,
We have not. That is separate and aside. They get to.
so then you guys won't be part of this conversation, these meetings. And if they come up with a solution that may require a rule change, how would you guys respond to this?
If that is their recommendation, then that is something we would bring before the board in our report in September, that the airlines and assessors recommend a different assessment scheme, and we would lay out what it would take in order to make that possible, whether it be a rule change, legislation, or perhaps something that may fit under the current statute or regulatory guidelines.
So then we could possibly be at the same position that we were last year, where we were thinking that we would need a rule change, and we haven't done anything to move forward for a rule change.
No, we have.
Yes. Let me qualify that answer. It is possible. It depends on how wide-ranging they are looking at in order to address the assessment of aircrafts. Last year, there was some talk about a rule change because there was a talk about using scheduled data versus actual data. The scheduled data is what is embedded in statute and in the regulations. But we have since moved away from using actual data, that it is now, the data set that we worked with is actual scheduled data. So unless that comes back up, I don't think that will be an issue, whether it's scheduled data or actual data.
So we would need a rule change if we were going to go with actual, but
Right, but that was not, that
that's,
was,
but
we
but
moved away from
we've
that.
moved away from scheduled data because of the compliance and administration burden.
I'm sorry, we moved away from actual data. We are working with statute.
We're going back to schedule.
Schedule, yes, ma'am.
And part of the my understanding is that the group is open to a discussion on.
Yes.
And that is potentially some statute change, and trying to get actually some statute change in an emergency statute process that would actually then take place through this year, which then we would know about by the time we come back in September, which then would allow us then to do whatever we need to do based upon the new statute.
Right.
If indeed that happens.
If indeed that happens.
Okay.
Okay, Member Harkey.
I'd like to move to postpone this till September, if that's the motion I need to make. I do think whenever you can get groups talking to each other, it's much better than us deciding on a lot of information that may in fact change in the statute if that's the road they're pursuing. So I will make that motion that we delay any decision here until September and ask the staff to kind of lay off further working on the issue until we have something definitive to discuss.
There's a motion?
I can second that motion with just.
Okay, and there's a second with some discussion?
Second, just some
Member
more
Stars?
discussion that the parties are talking, that is great. Just want to make sure that all the airlines have an opportunity to speak with the assessors. I don't want anyone to be excluded.
Well, and that's the danger that they run at
Yeah,
that point. If they
that's
don't, is
my
that all of a sudden we're
concern.
going to be back here and there's going to be competing airline opinion.
Yeah.
And that's going to be a danger for,
Because then we come back
Decision.
here in September, or December, and we
Yep.
don't have any agreement. So that's my only thing, I know it's not your meeting anymore, but I do, I know some representatives are in the audience, so please make sure that everyone's at the table.
okay.
Yeah.
Okay, there's a motion and a second. Member Horton?
I may be reiterating, but
Yes, sir.
there are different schedules that the legislature has, the Board of Equalization has as well.
Right.
And so there are other variables that may actually, other than the one mentioned, that may actually end up requiring a rule change. And so to the extent that we are aware of those because we've dealt with it historically, we might want to share that information with whatever committee is working on it, based on their arguments in the past, their positions in the past. If they were to go down this route, you would need a rule change, and here's what the process would be that might cause a delay in this process.
Yes.
The same thing if they're looking to sort of codify this in legislation. That would probably occur if it's September after the board has made its decision. And so I would not necessarily suggest that those are conditions that could impede the process. So at this point, it's just a matter of making sure everyone's aware of what all the requirements could be
Okay.
Okay.
in their
Okay.
deliberation.
Okay, there's a motion and a second. Any objection? Okay, that passes. Thank you.
Thank you very
Thank you.
much for accommodating me.
No problem. Glad to.
Thank you.
I'm sure you have a few things to do. Okay.
Excuse me, Mr. Runner, do we need Ms. Harkey for K31
K31, which
or our
is...
act?
Huh?
No.
We still have a quorum.
Okay, I wasn't sure if she wanted to participate.
No, I think we're good. Okay, let's go back to finish off the Executive Director's report.
Chair Runner and members, I'm Dean Kinney, Executive Director. With me today is Ms. Glenna Schultz with the Property Tax Department. As you're aware, we have essentially been functioning the first 5 months of this year without a legislative division. The chief position over the division has been vacant, although, as I previously mentioned, Mr. Mark Durham will be taking over that role starting tomorrow. Additionally, our one legislative analyst allocated to BOE as part of AB 102's the AB 102 split left the agency December 30th, leaving us with no coverage for the division. However, Ms. Glenna Schultz of the Property Tax Department volunteered to step in and help us out with the legislative matters. I'd like to take this opportunity to publicly thank Ms. Schultz for stepping up to assist us in a challenging time and for all her hard work the first part of this year. Your offices are being provided weekly legislative update memos as well as copies of the analyses as they are released. Currently, we are tracking 11 bills dealing with alcohol beverage tax, 8 of which are active and 3 that have been held in committee. 3 bills dealing with tax on insurers, all of which have been held in committee. 24 bills dealing with property tax. 9 bills are active. 3 bills have failed in passage in committee. 7 have been held in committee. 3 have not been assigned to committee. 2 bills have been chaptered, SCA 9 and SB 558, which places Proposition 72 on the ballot for next Tuesday's June 5th election. Proposition 72 would create a new construction exclusion for rainwater capture systems. We've done and released analyses on all 24 of the property tax bills. Additionally, we're tracking 44 bills dealing with general administrative matters to see if any will have any impact on the BOE operations. As for significant dates in the legislative process, this Friday, June 1st, is the last day for each House to pass bills introduced in that House. August 31st is the last day for each House to pass bills. September 30th is the last day for the governor to sign or veto bills passed by the legislature. Members, this concludes my report, and hopefully Mark Durham will be doing all of them in the future.
Okay, questions? Member Stowers?
Thank you. I want to say thank you very much for your analysis, Glenna. It's been very, very, very helpful. When we do have our chief on board, I'm just wondering, will we be going back to publishing the bill analysis on the BOE website? Because I don't think they're published anymore.
They're currently
They are
posted,
published?
yes.
They're posted?
Yes, they're out there.
Okay, I just missed them then. Okay, so they are out there. Okay.
Okay, Member Horton?
Thank you, Mr. Chair. Thank you. It's just a lot of work. You've done an awesome job. Very much appreciated. The question of Chief Counsel in this regard, AB 102 and 97 had a narrow description of the members' engagement in the legislative process, from my perspective. The question is, can the legislative unit, whenever it's fully established and functional, assist members in the legislation that they're in the process of developing for consideration by this body? And you can answer it later. You don't.
Yeah.
This body being this body or the board?
This
Okay.
body, the board. Historically, the Ledge Division has been of assistance to the members and just kind of developing the thoughts that have come from taxpayers. They've made requests regarding legislation. We've worked on the legislation. But the Ledge unit has been extremely helpful, as well as the economic unit is extremely helpful in just providing us with data. It's rumored, I don't know if there's any other way to put it, that no longer can happen under existing legislation, and I couldn't find that anywhere in the legislation.
And before we get a comment on the record here, because I want to be careful with a comment that may go on the record here for that question. I think it's an important question.
Right.
Let me just point out, in that edge, I would assume that the ledge unit that we would have here would be available to members of the legislature to assist them
That's
in
correct.
regards to issues and background. So again, I would be stunned if all of a sudden the legislature had more access to assistance from the ledge department than the members do. I would assume it would be the same.
Yeah, I make the same
So,
assumption. But
so that's why I want to be careful we don't get something on the record here that might need some
Gotcha.
further discussion.
So
Member Stowers?
I think
Well,
it's a similar question that I was going to present when we get to the next item on the agenda, but I think what Member Horton is really on point with respect to the Government Code Section 15600J. It basically says that the board members are not to interfere or influence
Right.
legislation, but it does not say anything else.
Right.
That's correct. I would like, because of the complexity and lack of clarity in AB 102, I'd like to take a more thorough look at it. But I would say preliminarily, clearly, the legislature could reach out to our ledge unit for advice. I think that there's a distinction in the one, in what the legislature's created through that provision, Ms. Stowers. The board cannot influence legislation that's being done either by the ledge unit in vis-a-vis their analysis or work they're doing for either the governor's office or the legislature, but to the extent that there's other needs that you yourselves as board members have, I don't think that that provision bars you from doing that. Likewise, earlier, you were asked by Member Gloria to support legislation. Again, I don't think that there's any bar from this board as a board voting to support legislation. That your First Amendment rights were not stripped from you when AB 102 was enacted. So that much I can that much I can give you. The rest I would like to look
Maybe
into.
should have been, but they were.
Okay. Okay.
One last question while
Yes.
Henry's here, the Chief Counsel's here. Historically, in the past, I think pursuant to the chair's request, we've received 3-day review of any legal opinions that have gone forth. I couldn't find anywhere that in the legislation, the new legislation, that prohibited that. I appreciate the staffing issue, and so I have not necessarily asked. Is it, whenever you come back, I certainly would like to know if that process can continue, and given the appropriate staffing to accomplish that objective.
I'm sorry, Member Horton, as far as legal opinions that we're issuing, my office is issuing?
Right.
Yes, we are, I may have stated it at a prior meeting, but because of the lack of staffing, we weren't generating that many legal opinions. It was an oversight on my part. I hadn't realized that those typically went to the board beforehand for lack of a better term, preview. It is now my policy to make sure that the board members get previews of legal opinions before they go out. I think there's been at least one or two that's been sent to your offices, and that will continue. That's part of the regular practice now.
And the process for members engaging your office just on legal questions, as we've done in the past.
We have a chief counsel report coming up after the ED, if you want to.
I thought we were in a rush, so I was going to ask.
Okay, well, just let you, he's going to be in front of you in just a minute again.
You'll see me a lot today, Member Horton,
Okay.
members of the.
All right, so we'll defer until you get that. Just remember the question.
Just get a heads up for about a minute from now. Okay, any other questions in regards to the legislative issues or any other discussion for the executive director? Maybe? Okay. Okay.
I guess it's more a question to us, since
Okay.
the board did vote to support one bill. Does that mean that the BOE will be writing a support letter? Who will write that letter? Okay.
And I would assume that if we write the letter, if the ED writes that letter, then indeed the ED staff then could go and present and
We'll
voice
follow
that
the-
support at a committee hearing.
We'll follow the former
Yep.
procedures.
Okay? Okay. Thank you very much. Now we have the chief counsel report.
Our next item is K2, the
I think there's a
Chief Counsel
question.
report. K1 is legal team
No
work.
questions.
Thank you. Thank you, Chairman Renner, Vice Chair Ma, members of the board. I will address your question, Member Horton, but I wanted to provide you a brief update on the legal opinion requests and the workload of the legal team. Under BOE 1.0, as we've called it, there were 8 attorneys, including a supervising tax counsel assigned to property tax matters. In addition, under BOE 1.0, there were at least 2 attorneys, including one tax counsel 4, who was almost entirely dedicated to handling property tax and tax on insurers litigation matters, as well as some work on litigation being done by the assistant chief counsel over litigation on property tax litigation matters. There were also 2 additional attorneys dedicated to board member matters, disclosure issues, and legal matters relating to the board. And then there was at least one other attorney who handled personnel matters. It was very interesting reading for me to look at prior organization charts and kind of ferret this information out. As you may know, from September 2017 until February 2018, you had myself and 2 attorneys to cover this workload. In February, we were transferred 4 more attorneys. One of my attorneys went on leave at the end of February and won't return until the middle of July. Thus, we have 6 attorneys covering the work that was previously handled in whole or in part by 14 attorneys. Although my staff has made a valiant effort to keep up, we are falling behind in responding to taxpayer opinion requests. Since January 2018, the legal team has had over 190 assignments comprised of legal opinion requests, reviews for guidance or of guidance and other documents, reviews of legislative analysis, and other assignments. In comparison, as far as I can tell, last year we had 289 such assignments in the entire year. Although the tracking may have missed some assignments during this time, that clearly indicates that we're, at this point in May, well over 50% of the workload of last year. Clearly, in 2018, we have had a greater number of assignments. The legal team has had to prioritize our work efforts by giving priority to, 1, time-sensitive matters, including legislative analysis, 2, staff or program needs. 3, requests for legal opinions from the assessor's offices. And 4, requests for legal opinions from taxpayers. Some of my staff has opinion requests dating back to 2017 on their workload. Private individuals' taxpayer opinion requests are kind of unfortunately low priority, so that's kind of where they are. Approximately 10 such assignments from 2017 are still pending. We have about 25 of those kind of requests from this year's workload still remaining. I am currently handling litigation matters, personnel matters, and board-related matters for the BOE, and trying to keep my team, to leave my team entirely available to concentrate on the property tax workload. But I am trying to share some of my workload with the staff and get them trained up in some of these things as well. And then that's my report in a nutshell.
Is your team do we still have a situation where you are located in a different place than the rest of your legal team?
Not entirely. I have
Okay.
an office in the building with the legal team, so I kind of go between
Okay.
621 and here as well. So I have a presence in both places.
Okay.
Member Runner, you had a question.
Well, I did, oh, no.
Member
Member Horton did.
Yeah,
Sorry.
yeah. Another question now that you've been able to give your presentation. Thank you
Sure.
very much for that. In considering your workload, is there any consideration to hiring contract labor, as much as I oppose that in any other world, but
That I have looked at every alternative possible to get some assistance. The problem is, the other issue, as I understand it, is our BOE 2.0 budget is very, very light. So I'm kind of struggling to even cover the litigation matters that we have outstanding right now. Some of the litigation matters has required me to travel to the various venues in which they're the courts are located or the matters are venued, and the budget's going really fast. So unfortunately, we don't really have the budget for outside assistance. We have been using the AG's office. They have been very accommodating as far as our needs. That's actually been what I've been kind of using as a safety valve, and we do have to pay for them as well.
Okay,
all right.
thank you.
Sure.
Any other- Okay,
I believe he knows the other concern.
Ms. Richmond, the next item.
Our next item is K3, the Property Tax Deputy Director's Report. K31 is the adoption of 4R Act Equalization Ratio for fiscal year 2018-19.
Good morning, Chairman Runner and members of the board. I'm Mike Harris, manager with the State Assessed Properties Division. And the item before you is the 4R Act Equalization Ratio. The 4R stands for Railroad Revitalization and Regulatory Reform Act that was enacted by Congress in 1976. Revenue and Taxation Code Section 1817 requires the board to conduct a study and determine the statewide and county-by-county ratio of assessed value to fair market value of commercial and industrial properties. Staff conducted this study using the 2016-17 property roll that yielded a estimated statewide ratio of 60.73%. This is a decrease of 3.44% from last year's 64.17%. Therefore, staff recommends the board assess rail transportation property at 60.73% of market value for the 2018-19 roll. Thank you.
Okay, discussion, members? A motion?
So move.
Motion by Member Stowers,
Second.
a second by Member Ma. Any objection? Okay, that passes, thank you.
Great, thank you very much.
Okay, what's next on our agenda?
Next is item L, Board Member Requested Matters. L1, Board Committees.
Okay, this is an item that I put on for at least for the sake of discussion. I know it was at least an item that another member had a thought on too, so I thought it'd be good for us to deal with that and the need, and if there is a need. I am not at this point trying to promote the fact that we have to have committees. I'm not promoting the fact that every member, if we have a committee, needs to have a committee. I'm basically wondering if there's an interest within this board or a desire that where there could be some specific energies given by a board member in a subcommittee, or basically in chairing a committee, but remember, these committees will continue to be a committee of the whole. And so it'd basically be the kind of work and relationship that happens prior to a meeting, and then the committee would participate and happen the same way it is that they did in the past when we meet as a whole. So anyhow, I knew some members had a concern about this or an interest, so that's why it's on the agenda. Member Starr.
I go first. I think there could be some value in having some committees, especially if it relates to property tax, which is what we do here. But my question is really to Chief Counsel. If we were to establish standing committees, and if we were to hold IP meetings within those standing committees, and we notice the meetings, would we be able to attend the members or their designees without violating the Open Meeting Act?
Yes, you would. You would be fine attending or your designees if they are properly noticed. It might affect, as I understand it, and again, you were here before I was, so I don't know if under BOE exactly how IP meetings worked, but as a noticed meeting, for example, I think I presented a memo to the board members about the rules regarding IP and Bagley-Keene. You wouldn't be able to ask for, obviously, folks to identify themselves. You do a sign-in sheet, things of that nature, but other than that, there would be no problem requesting or having an IP meeting within a committee meeting.
Why no sign-in sheet? I mean, at another board, they have IP meetings. Maybe because they don't have, they have a sign-in sheet. But when the member of the public speak, they don't attribute that comment to any one person.
Yeah, there would be a question as to whether you could require somebody. You can have a sign-in sheet that's optional, but you couldn't require people to sign in to attend the IP meeting.
Okay, optional.
Correct.
Optional
That would be fine.
sign-in.
Yes.
Okay. Okay.
So just to clarify, my understanding is at the IP meetings, one of the things the staff tries to do is tries to get an identification of all who's attending, so they have a flavor for who's been participating and who's aiding in the conversation, if you will. That would be somewhat limited because it would be an optional sign-in, and people couldn't be required to sign in or identify themselves.
Okay, I understand that. And then if we were to have these committees, and then, kind of changing the question now, and the member is the chair of the committee, would we have a problem with AB 102 with the member directing a BOE 2.0 employee, let's say, the chief of property tax? Will they be directing that person just by being the chair of the committee?
I would recommend, and I can provide some more details, but I would recommend some caution. The way that works is in a committee, you're having a discussion, you're kind of addressing the issues. At the end of the day, if the committee chair is a board member and they want to have the chief of property tax do something, the proper to not run afoul of AB 102, all that board member would do is contact the executive director, who usually, as I understand, regularly attends those committee meetings in the past, and have them direct the staff.
Okay.
Chair Horn?
Is it possible, I mean, the legislation also allows the executive director to designate individuals to assist in whatever, in this particular case, is it possible that the executive director could actually direct someone, and so they are his representative and more or less a conduit? I mean, I hate to require the executive director to be in all these meetings, considering all the other meetings he's got to attend. Is that possible?
I think that's fair to do. The executive director does have that authority. I would recommend that he exercise that with more higher-level employees in his organization, but that's something clearly he could do. He doesn't have to physically be present at each meeting.
Yeah, I think, for instance, the easy example I would come up with, for instance, if we established a legislation committee, there is a CEA who is basically then overseeing and dealing with that that particular place in the BOE. And then the executive director could indeed then assign that person to
Work with that
attend
committee.
those committee meetings with clear communication then between both the member who would be working there and that individual CEA as to what the guidelines are for how work needs to be produced and not produced.
Correct.
Is that fair?
And that would be perfectly appropriate under AB 102.
The other option would be, instead of standing committees, to actually have standing agenda items that allows for allows for all these issues to be discussed at a board meeting.
True.
I'm open to both.
Yeah.
But I think having a standard agenda item kind of also allows provides a communication to the public as well, that at any given point, these are the issues that the board will in fact consider collectively. Especially given that ultimately it comes to the board anyway, so it may actually skip a step, save us some time.
The one that stands out to me that I think, even a little bit today, we saw that it seemed to me that did serve a good purpose and was helpful was the legislative committee, or legislative or legislation committee.
Well, it could be a budget committee, 'cause
Well, I'm just talking about but I mean,
legal committee.
that had a very specific role and I think also then has this connection back to the legislature, because oftentimes what happened is when the legislature wanted to contact, they needed to know who to contact. And so it became almost an easier point of contact to say, okay, this is the board member you want to talk about to if you want to go ahead and schedule something. And then that person, that board member, would have the ability, as the chair of that committee, then to work that out within the committee, within the meeting structure. So that at least, that to me is one that it seems to me served an interesting purpose and I could see purpose going forward at that point, too. The others become a little more dicey, I think, when we start dealing with budget committees and things like that in regards to what are the curbs that we exist now under the new legislation. So that's kind of my observation of that.
Well, to reestablish this, we need a change in the tax appeals rules. Is that correct?
Correct. We need to work on
So you'd have to
that.
bring this back before the board?
Well, if we would, one would, if it were standing, I would think it would go under the chief counsel.
Chief counsel
Yeah.
for a rule change? Okay.
Would be the logical for me.
Yeah, I think so.
What's that? I'm sorry, what?
To have the committee, we need to change the
That's how they
What?
established.
I'm sorry, what are you saying? What do we need to do?
I think you're saying before, when we updated tax appeals, I don't know if it went through committees, but how.
But I'm sorry,
it was
that's a different discussion, though, rather than establishing committees.
I thought that, I'm just from memory here, I thought that when we established the committee, it was done through the rules of tax appeal, part of the process. But you can go back and look at it and come back and let me know.
Okay.
Okay, if it's embedded in the, okay.
Yeah.
So I
I'm
guess
not
at
familiar
this
with that.
point,
I'll
my
take a look.
question would be, is there, and again, as I would see this going forward, if there's a desire to identify committees into the future for the board, that we would then decide, maybe the decision today is that, yes, there's a place for committees in the future, and then what we would decide maybe is to focus on the ED, and members can have communication to the ED with suggestions as to what those committees could be, and then we could then come back and then deal with the adoption of whether or not those committees are indeed something that we would like to do. Because I think one of the issues that I think it needs is it not only needs the step of do we need committees, and what are the names of those committees, but what are the parameters for what we have under the law be able to operate within that committee. So I think that's something that, again, the ED's office can help us do, and that way we have something specific to present to us. And again, I for one, did not feeling like it seemed to me in the past, everybody had to have a committee. If we only have a need for 2 committees, then I think we have 2 committees. And we go from there. So I guess the question before us is, do you have an interest in at least exploring some certain kinds of committees to which we would ask the ED to work through based upon suggestions that members would have to him?
Well, personally, I welcome the work, but not the committee. But I would defer to the members as to what they want. I wouldn't be an impediment in that process. But I do believe that public discussion at the hearing with an agenda item would probably be the best way to accomplish the objective that we want to accomplish. And I do believe that those activities can be handled through the office of the chair, and we should probably give the chair and a couple other staff people.
Again, I don't have a plan here, so, but if that's the feeling of the board, that we don't need to do that, and that all these items can be covered by the board itself.
No, I think we should look into it. That's just my concern. I mean, I don't really.
Well, I don't want to put them through a bunch of work if there's not a desire by the majority of the board to have committees.
I don't think we need committees anymore.
Okay?
I mean, before, having the different committees, we had a lot more issues under our jurisdiction, and now, like, if we have legislation, so I remember Gloria came and took care of that. If they really want us to weigh in and, be on official notice to support legislation, I think it's not that much now. And then the other, committees that we used to have had a lot more work, I think, before, so.
Okay?
I'm okay with that.
Okay, I think there's a consensus here that we don't need to go down that path.
Okay.
I think there was a concern that, an interesting issue that Member Horton brought up, is that we may want some standing items on the agenda.
Sure.
And that's an interesting issue, and maybe at that point, for instance, I would think legislative issues could be one of those, because that seems to be always something that's there. And then if a member in the legislature wants to come in, it's a place for them to come in and tuck in and have that discussion. It's a place for the other issues for the ED to bring up on issues. So, Member Horton, you were about ready to say something.
Yeah, I just wanted to, I think the workload is even equal, if not more, than it was before. So depending on the committee that you establish, the legislative committee would have, in my opinion, this year would have had significant amount of work to do, if for no other reason, just to be engaging with the county assessors. We got 58 assessors, over 3 million constituents. It's just, and historically in the past, it's been priorities, so there's a shift in priorities, not necessarily a decline in work, as the chief counsel has indicated. Quite a bit of work there, but you have to prioritize it. And so in the past, historically, the committees have allowed us to prioritize the work. In this case, the board has established priorities, and the work is there, significant amount of work for various different committees or agenda items. I favor the agenda items because of the increased transparency in the process.
Okay, well, it seems to me there's not consensus to move forward on that item with the committees, and the idea of maybe having more specific items to the agenda. I'll work with the ED in regards to how it is in the chief counsel, in regards to how those could appear on the agenda.
Great.
Okay, thank you.
Thank you.
Okay, the next item I think was we've already dealt with, correct? That was the
We have L3.
We have L3,
L3.
recommendation for board positions on
L3, where am I?
ACA 24 and 10.
L2, and then we're into L3, right, okay. L3, I think we dealt with too, right? No, nope, that's a
No.
different one, I'm sorry. Okay, L3. Ms. Horton, that's you.
Thank you, Mr.
It's your deal.
I just let you work through it, sir.
I'll get there eventually.
Yeah, members, this bill was, the matter was brought forward as a result of the calamities, fires all over the state of California, and so we received calls not only from various different assessors, but also taxpayers who expressed concerns about them being able to transfer their tax base in the event that their home burnt down or some other calamity existed. Currently, under current law, only when there is an agreement between the county that the counties have an agreement that you can transfer your tax base from one county to another. Under the current circumstances, there are about 8 individuals, 8 counties that have concurred. The other 50 have not established that for whatever reasons. And this bill will establish and allow individuals who have suffered a calamity to transfer their tax base. The bill is projected by the Board of Equalization to have a cost, but we believe that cost, based on historical data, where in the past less than 0.06% of the individuals have actually transferred their base value. They really want to go back to their home. They usually only transfer when there's financial challenges that exist. They needed to downsize anyway, and now they're forced to build at a certain code level in the existing, so they need to go, and other personal reasons for individuals wanting to transfer their base value. So we believe that it's nominal, and look forward to having that discussion based on historical data with the appropriation committees.
Okay, right now, the ACA, which has to happen in order for the
ACA hasn't been assigned to committee. I just learned to that. In order for the bill to be effectuated, the ACA would have to be assigned and would have to go through the process as well. The legislation 1091, I believe the legislation has currently been referred to appropriations.
They got held in suspense.
Got held in suspense like everything else. So, again, you know, for myself, members, this was more of a communication to the constituency that we care about the problem.
Can we get,
Problem exists and we care about it.
I think, to me, since we're watching it, maybe the appropriate issue would be in next month's meeting, we'll know whether the ACA is moving. And maybe we can have a discussion about if that
Put
time
it over.
it's moving. If
Put
it's
it over.
moving, then we may want to take a position on the issue.
Okay, I'm good.
Yeah, and I just want to add, I think this is an important issue. I was just in Lake County this past weekend, and there are a lot of homes that are not being rebuilt for various reasons. Perhaps it's, building lot changes, insurance, people that just didn't want to rebuild again and had to move to different counties. So I do think that this is a
Yeah.
very real issue.
Okay, so let's watch it, and if there's something that we need to be dealing with, we can do that, okay? Okay, what's next on our agenda?
Our next item is the public comment on items not listed on the agenda.
I think we have a statement to be read.
Correct.
Thank you.
Chair Runner, Vice Chair Ma, members of the board, just as a reminder, since we don't do this very often, this is public comment for matters not on the agenda. It's not an issue that we need to, the board needs to respond to. We're just taking the public comment, so.
Okay, before she makes the comment, I appreciate that. But can we, after you give us your verbal comment, can you give us a written summary as well to the board on the issue at hand so that I could keep tracking it?
Sure, I'm able to do that.
Yeah, absolutely.
So, good morning, members. I'm Lisa Thompson, Chief of the Taxpayer Rights Advocate Office. And as indicated by the Chief Counsel, I will be reading a public comment submitted by Mr. Sean Mooney. I will read the statement exactly as is. There are a few words missing, so the omission is not my error in reading. By my reading the statement, I'm not affirming its accuracy. So the header of the document reads, BOE Public Comment, May 30th, 2018, Government Code 15606H, Enforcement Mandate, Annotation 160.0050. The remainder of the document reads as follows. Urgent constitutional crisis. The tax advocate erroneously determined the duties of the BOE did not include enforcement authority to compel a local board or assessor of its mandated duty to not allow any property to escape taxation. Annotation 160.0050 and Government Code 15606H clearly mandates the enforcement of all property tax laws and regulations. Revenue and Tax Code 480.5 requires the reporting many different types of grants that create taxable possessory interest on public land. Government Code 15606D specifically requires the BOE with enforcing all prescribed forms. However, there is no form available for reporting private usages of license agreements, use permits, concession agreements, and other types of private occupations on public land. In September 2016, Mooney filed a taxpayer complaint per Revenue and Tax Codes 1362 in San Francisco, identifying 12,714 private use permits on public land that were not reported to the assessor and not enrolled, and do not have a base value. Further, none of the 12,714 private use permits have tax-exempt status, thus escaping taxation. The state constitution requires all property is taxable unless exempt, and the 12,714 private use permits are neither exempt nor taxable. San Francisco, lacking the necessary educational knowledge and procedures to make a determination regarding Mooney's taxpayer complaint, requested a BOE opinion on October 30th, 2017. Mooney's taxpayer complaint remains unresolved until the BOE is responsive to San Francisco's requested opinion letter, asking 7 questions related to Mooney's taxpayer complaint. Government Code 15606H specifically mandates BOE duty to seek enforcement of all property tax laws and regulations. Annotation 160.0050 articulates 15606H as required when no remedy is available to compel local board and assessor to enforce tax laws and regulations. Board members, San Francisco's requested opinion letter requested 7 months ago remains not forthcoming, thereby not resolving the 12,714 escape assessments that will reveal the same problem statewide. The new tax advocate appears conflicted in her fiduciary duty to protect the public in determining the BOE has no enforcement jurisdictions. The tax advocate refuses to take urgent corrective actions to mitigate further massive losses to public revenues by implementing corrective actions before the July 2018 lien date. Sean Carl Mooney. The footer reads, Gov Code 15608, Attorney General's opinion and referral requested BOE enforcement authority duty to compel tax laws, Gov Code 15606A through H.
Okay, thank you.
Thank you.
So, excuse me. Sorry.
Let me ask,
Ms. Thompson?
Yeah.
let's clarify, what amount of discussion can we have on an agendized item at this point?
You can, it's not agendized, but you can ask general questions to Ms. Thompson.
So this appears that this is the new, agenda item. You're going to read letters? I don't understand why.
No.
No, I'll respond to that. What happened is, this has been an issue that we've had a constituent out there who wanted to make a public comment at that point. They did at one point, in fact, it was a meeting I wasn't here. At that point, then, it was referred to the Taxpayer Advocate's Office. This individual then the Taxpayer Advocate's Office responded, clearly, it is indicated in the second letter. They did want to then read a statement again last month. Our response, the chair's response was, no, let's wait and see what the Taxpayer Advocate's Office says to you. And so that's why it didn't appear last time. And so they now responded, since the Taxpayer Advocate's Office has responded. My decision was then to go ahead and let them respond one more time, based upon then the new information of our Taxpayer Advocate's Office. At this point, I think we have finished off what we can do. There's no new information at this point. It's clear, I think, from Chief Counsel's opinion in regards to our lack of authority in this area.
Correct.
And therefore, I do not see the need for this to be happening again. And that's how it got accommodated as a letter, because the individual has requested it under an ADA issue, and so that's why it came as a letter instead of the person being here.
Okay, so what is the conclusion? Because he is on our radar, clearly on all of our radars, and so we would like to kind of have a conclusion. I don't understand.
So this, the board can follow up a little after the meeting with the taxpayer rights advocate and the executive director of all the responses that BOE has provided this individual. This individual first contacted us, I want to say, well, probably contacted Board of Equalization executive staff prior to September of last year. I have responded to him numerous times. Mr. Gao, your prior executive director, has responded to him numerous times. So has Mr. Reisinger. So has Mr. Young. He has kind of made his rounds essentially with the same argument. Unfortunately, what the Board of Equalization can do in this particular instance is very limited. We have tried to explain that to him. We have provided numerous responses, yet he continues to want to have a
When you
public
say very
comment.
limited, do you mean very limited, or you mean nothing?
Very limited. There is an opinion that he has talked to San Francisco assessors about. I apologize, but that is one of the lagging assignments that my attorneys are working on. We plan to get that completed in the next 30 to 60 days, and that would pretty much complete our ability to assist this individual taxpayer.
And so are you also working with the San Francisco Assessor's Office, Ms. Carmen Chu?
Yes, Ms. Chu, as I understand it, Ms. Chu's office has reached out to us to ask us to, on some questions regarding a particular form and how that should be handled, which is one of the many issues that Mr. Mooney has brought up. That's the only issue that we have we can provide some guidance in, and we're in the process of doing that.
Okay, all right.
Okay,
Great.
thank you.
Thank you.
Ms. Richmond, our next item.
Our last item for today is closed session. The members will now go into closed session to discuss pending litigation and personnel matters.
Okay, thank you. Okay, report from closed session.
The board members met in closed session and discussed pending litigation and personnel matters, and there's nothing to report out.
Okay, with nothing left on the agenda, this meeting is adjourned till next month.
Thank you.